Hello everybody. As you are aware that we always have a program on 3rd of Saturday where we had lectures on various topics. But unfortunately after pandemic that particular venue is not proper, it is not available, there are certain problems. But still we have continued with the program. The only thing is now in that time the guest was called to us. Today we go to the guest and there we take the interview. Identically today I am with A.V. Deshpande sir. Sir started his practice at Nagpur court 1975 to 1980. In 1980 sir joined the judiciary and finally in 2012 sir retired as district and session judge Jaisinghpur district court in Kolhapur district. Subsequently from 2013 to 2017 sir was president of district consumer dispute redressal forum at Sangli. In 2017 to 2019 sir was chairman of internal grievance committee of MSE DCL. After that, the sir, as on today, is chairman of the internal grievance committee of Shivaji University, Kolhapur. So, sir will be speaking on a topic appreciation of evidence in criminal cases. So, sir, without wasting more of my time, I would request you to commence your guidance and lecture on this particular topic.
Thank you, Rahul. Ever since I have retired from the judicial service, I am coming in contact with the people at large who otherwise had no access to me due to the distance which, as a judge, I had to maintain. I find that the people are very curious to know as to how the trials go on, how the evidence is laid before the court, how it is appreciated by the court, how the judgments are written by the judges. People are often found to be surprised as to how, despite the substantial evidence laid before the court, the accused is acquitted. Their normal expectation appears to be that once the police have investigated into the offence and have built up the case against the accused, and the witnesses are examined to depose before the court, how the accused is acquitted. If an accused is a celebrity or a person with some standing in the society, the people are invariably interested in following that particular trial. They do so through media, or sometimes they are made to follow the trial by the publicity in the media. Many times the exaggerated versions of what witness has said before the court are given out. It might happen that a particular interpretation of a deposition of a witness is purposefully spread out. A person can be easily influenced by such interpretations and he forms his or her opinion about the outcome of the trial. If the result of a trial is different than the expectations of the people, then many things which I may not state here do follow.
Okay.
I think it is absolutely necessary that the people at large should know as to what is the evidence, how it is laid before the court, how the evidence is appreciated by the court, what is the degree of proof that is required in a criminal trial, what is the cardinal rule of criminal jurisprudence, what is the presumption regarding the guilt of an accused, how that presumption has to be rebutted and by whom, on whom the burden of proof in a criminal trial lies, what is the extent of the burden of proof on an accused, and under what circumstances he has to discharge the same. If the common man has the basic knowledge of these aspects, then I think a lot of misunderstandings and misgivings will go away. I thank the organizers for giving me this opportunity to share my thoughts on this subject with you all. I gather that most of the viewers are the law students or the lawyers who have just started their career in the field of law, besides the common people, who I think should be educated in this behalf. Before I begin, let us understand what is the meaning of word evidence. The word evidence is derived from the Latin word evidere, which means to show clearly, to ascertain, or to prove. The word evidence is something which makes evident something to someone. In the field of law, the evidence is understood to mean something which makes evident a fact to a judicial body, that is the court. In the law of evidence, the word evidence is interpreted in section 3 thereof. It is an inclusive definition, and it says that evidence means and includes, first, all the statements which the court permits or requires to be made before it by the witnesses in relation to the matters under the inquiry. Such statements are called oral evidence. And second, all those documents, including the electronic records produced for the inspection of the court, such documents are called documentary evidence. The object of giving evidence, both oral as well as documentary evidence, is to enable the court to form its belief in the truth or otherwise of the alleged occurrence, crime, and the guilt of the accused. It has to be borne in mind that the occurrence of an incident or offence and the fact that the accused has committed that offence are the two most essential facts which had to be established by the prosecution. The burden to prove these facts is always on the prosecution, and prosecution has to prove both these aspects beyond all reasonable doubts. The criminal justice system does not leave any scope for any doubt when it comes to proving the guilt of the accused. The court has to form its belief in the truth or otherwise of the alleged occurrence and the guilt of the accused by evaluating or correlating the various factors, proved facts appearing in the evidence, on which the proof of the guilt of the accused is made to rest. And how do we say that a fact is either proved, disproved, or not proved? Each of these three words have very categorical meaning. When, after considering the evidence or the matters before it, the court either believes the existence of a particular fact or considers the existence of a fact to be so probable that any prudent person would act on the supposition that that fact exists, this fact is called a proved fact. When considering all the material placed before it, the court either believes in the non-existence of a particular fact or considers the non-existence of a fact so probable that any prudent person would act on the supposition that that fact doesn't exist, then we say that it is a fact disproved. And the fact not proved is if it is neither proved nor disproved. So I think the difference between these three is quite clear. When, after considering the matters before it, the court either believes that a fact does not exist or considers its non-existence, I think I am repeating this, the law enjoins a duty on the court to base its judgments upon the facts declared by the evidence as to be relevant facts and duly proved facts. We have already seen what are the proved facts. Now, the relevant facts are those facts are the facts which are supportive the purpose or the contention of a person. They lend corroboration, support to what has been stated by the witness. In the criminal trials, the burden to prove the guilt of an accused is always on the prosecution, we know that. It has to establish or prove the guilt of the accused beyond all reasonable doubts. The law presumes that every person is innocent unless proved otherwise. This presumption is dislodged only when the fact is proved beyond all reasonable doubts that the accused has committed that offence. This burden never shifts from the prosecution. Even if the accused takes defenses like alibi or right of self-defense or insanity and whatever permissible exemptions are laid down by the criminal code, penal code, then the burden to prove those aspects is not so high as that of the prosecution.
Oh,
It is sufficient if he creates the preponderance of probabilities which run parallel to his defense and creates a strong probability that his defense might be true. Then he makes inroads into the prosecution evidence. The burden to prove all these defenses on the accused is akin to the burden of proof laid on the parties in a civil suit, which is the preponderance of probabilities. In civil cases, you are not required to prove your claim or defense beyond all reasonable doubts, as is in the criminal trials. The burden of proof means that responsibility to lead evidence, which, if not led by a party, that party must fail in its contentions or the claims. That is the burden of proof. In the criminal cases, the trial begins when, after considering all the prima facie material placed before it, the court frames charge, and that charge is framed of the offence which is prima facie made out from the material which is placed before it. Whatever the offence is found to have been prima facie committed, the charge is framed on for that offence. And thereafter the plea of the accused is recorded. The accused may plead guilty to the charge, or he may not plead guilty to the charge. If he pleads guilty, then the court can straightway convict him and sentence him to the imprisonment or pass or whatever appropriate punishment is there. But when he pleads not guilty to the charge, then it becomes obligatory for the prosecution to lead the evidence and to prove the fact that the accused has committed the said offence. There are many authoritative judgments of the Honorable Supreme Court as well as the High Courts on the point as to what amounts to a reasonable doubt. To discuss this aspect, it would entail a lengthy discussion. Suffice it to say, and in fact, the sum and substance of the case laws laid down by the Supreme Court as well as the High Court is that the doubt which is contemplated need not be a fanciful doubt. And it must be a doubt which is necessarily created in the minds of a reasonable person. The law does not require anywhere that for proving the guilt of an accused, any particular number of witnesses is required. It is not the quantity but the quality of the evidence which is necessary for establishing the guilt of the accused. Even if there is a single witness to the crime and the case against the accused rests on his evidence, if the court finds his evidence is entitled to the full credit and it inspires the confidence about its truthfulness, then his evidence would be sufficient to sustain a conviction. In a number of cases, I had been occasions to convict the accused persons on a single evidence of a police officer, or the single witness, which inspired the confidence about his truthfulness. A conviction can be based on the solitary evidence of a police officer also, because in the words of this Honorable Supreme Court, in a very old case of which citations I don't remember at this stage, the Supreme Court has said that a presumption that a man acts honestly is also applicable to a police officer. Of course, this presumption is rebuttable, and if it is rebutted from a cross-examination, the evidence of that witness is shattered and can't be accepted. Of course, these occasions wherein petty crimes like gambling, prohibition, so on and so forth, where the panchas keep on regularly turning hostile and not supporting the prosecution, and that left us with the solitary evidence of a police officer. The convictions could be based thereon, and I may not boast about it, but maybe. After all the evidence, both as well as oral evidence, documentary evidence is laid before it, the real task of the court to appreciate the said evidence begins, and this is where my topic starts.
Okay.
Believe me when I say that it is most challenging task of a judge. To find out the truth is an uphill task. It is like trying to search for a pin in a haystack, and also like sifting the grain from the chaff. There is no set formula for appreciating the oral evidence, and there can never be. The oral evidence is always dependent on variable and inconsistent factors, such as the human nature. There is no set measure for weighing the evidence or inference arising therefrom. That depends solely on the facts of the particular case. The appreciation of evidence depends on the common sense, knowledge, and the experience of life of the concerned judge.
Okay.
It also depends on the perception of a judge. Let me tell you one story which I had heard very long back, in my childhood probably, that there were 4 blind people who were blind since their birth. They were curious to know as to what the elephant looks like. Obviously, they could not see the elephant. So they were taken to an elephant, and all of them were made to touch each part of the body part of that elephant. And they were made to jot down or state their impressions about the animal. So one of them had touched, felt the leg of the animal, and then he said that the elephant is like a trunk of a tree. Someone had touched the tail of that elephant. He stated that elephant is nothing like but a rope. Someone had touched the ears of that animal. He said that the animal is like a fan, and so on and so forth. Somebody had touched the trunk of that animal, and he said that it is nothing but a muscular pipe.
Okay.
So this is how they had perceived the animal, and they had recounted their impressions about that animal. So this is the perception. This perception has to be seen. So one fact, animal, is seen differently by different people, and each one of them carries a different opinion about that particular fact. And this is exactly what happens. Therefore, the court says, the law says that it is based on the knowledge and the experience of the life of the particular judge as to how he sees it. When there are conflicting versions in the oral evidence, the witnesses may slightly different story from each other. There can't be any mathematical precision in the statements made by the witness. The task of appreciating the evidence becomes more difficult. In that case, the judge has to apply a fair amount of common sense, shrewdness, his knowledge and experience, at the same time taking into consideration the ordinary course of events and the human conduct. If after applying all these tests, the judge finds that there is a reasonable doubt about the guilt of the accused, then the benefit of such doubt has to be given to the accused. He is entitled to that. There cannot be any mathematical precision for appreciating the evidence, that which I have said. To appreciate the evidence is an art which is developed by the judge by his own experience in the field. In the criminal trials, the oral evidence of the witness is most important. The courts have to rely on the oral evidence of the witnesses in order to come to the conclusion as to whether the occurrence of a crime and the fact that the accused has committed the offence or not. Surely there would be documentary evidence laid by the prosecution, but that is in the form of the corroborative piece of evidence, like spot inspection, the injury certificates, seizure memos, and so on and so forth. These are all these corroborating circumstances. The primary evidence in this case, the criminal cases, is the oral evidence of a witness. Sometimes there may be confessions of the accused, but that is altogether a different aspect. In order to help the court to come to this conclusion, the evidence of witness has to be truthful and capable of inspiring the confidence of the court that the witness is deposing truth. To form this opinion, the court has to critically examine the evidence. It has to see as to whether the evidence of a witness is in conformity with the ordinary course of human conduct. The natural course of events and whether the statement made by the witness is probable. These are the other two things, important things, which are to be borne in mind by the court. The effective cross-examination of a witness by an accused helps the court to a great extent to come to these conclusions. But even if there is no cross-examination or any effective cross-examination, it does not relieve the court of its duty to test the evidence. The evidence has to be tested by the court. It cannot act mechanically. In Deshpande versus Collector Raigad, reported in AR 1969 Supreme Court 255, the Honorable Supreme Court has laid down that in weighing and evaluating the evidence, the judges are bound to call in aid the knowledge and their experience of life in discovering the truth. When the evidence of a witness does not confirm the probability of the transactions which he is deposing, to which his evidence has to be rejected, or his evidence has to be regarded with the suspicion. If it doesn't conform to the natural course of events, his evidence can also be outrightly rejected. This is very important principle in appreciation of an evidence. I am reminded of a case which I had an occasion to try, which involved a father with the allegation to have ravished his own daughter of 12 years age and to have murdered her. The prime witness in that case was an eyewitness to the incident, and she was the mother of the girl raped and also the wife of the accused. Objectively, her evidence could be straightway accepted on the supposition that no wife would depose falsely against her husband or would falsely implicate her husband, particularly when he has ravished his own daughter. As I said, this is an objective appreciation of that evidence. But as we have seen that we have to strictly scrutinize the evidence, and that evidence of the lady did not inspire any confidence. Her conduct in the cross-examination, disclosed in the cross-examination, was absolutely abnormal. Like for instance, the case was that this man was spending his nights in a shade which was slightly away from his house and leaving his wife and daughter and other children in the house. And Every night he used to go to that shed. This girl, which was raped and murdered, was so scared of that father that she used to leave the house for days together. She had to be found out, searched out, and then brought back, etc. And then the man used to beat her, so on and so forth. The lady is deposed, the prime witness deposed that on the day of incident, the similar thing occurred. In the night, that man came for the dinner in the house. The girl was brought, fetched from somewhere by her younger sister. They had a dinner. This accused shouted at her and dragged her to the shade, saying that now I'll show you, teach you a lesson. The prime witness said that after tidying up her kitchen and all that, she went to that shade to see as to what is going on. When she came near the shade, she found that the door of the shade was closed, and she was hearing the shouts of her daughter. So she just peeped inside through a hole in the wall and found that the man was ravishing and was engaged in the act of this thing, and the girl was shouting. This mother made some noises as to what is going on, etc., etc. And according to her, the accused shouted from inside at her and asked her to go away. Now, this lady simply went away from the shade, went into the standing crop in the field, waited till the shouts of her daughter subsided, and when they stopped altogether, she thought that now the girl has slept, she has gone to sleep, and then she simply returned back to her house. Next morning, as a dutiful wife, she took a hot water for her husband to take a bath to that shade. And after going to the shade, she found that the girl is not there. She asked her husband as to where that girl has gone. Her husband said he doesn't know, and he should not be asked about her. After her husband took a bath, after she tied up that shade also, she came out of the shade, only to find a huge gathering of people at some disused well, which was at some distance from the shade. She started going there. All these things have come into her cross-examination. She started going to that well. She was obstructed by some ladies. She was not allowed to go there. Hence, she came back to her house. But after 1 hour or so, she could not resist herself. She went to the well, and only to find the naked body of her daughter brought out of the water. And the police were present there. They were drawing Panchanama. And after seeing the girl dead, she is returned back to the house, started crying. She stayed in her house till about 5 o'clock in the evening. And then she decided to lodge the report. She had to walk all the 5 to 6 kilometers distance up to the police station where it was situated, and there she lodged the report at about 8:30 p.m. Now, if we consider the conduct of the prosecutors, the complainant, do you think that it is in conformity with the natural conduct, natural reactions on the part of the mother who sees that her daughter is being ravished? The cross-examination revealed that that lady had so many grievances against her own husband. That fellow was totally failure in all the walks of life. Whatever business he had started, he had lost everything. This the woman was reduced to work as a housemaid in the other's house, so on and so forth. So, coupled with all these things, plus she not taking the opportunity, seizing the opportunity of informing to the police who were present at the well, drawing the Panchanama, that her daughter was ravished by her own husband and all. All these things were too good to place any reliance on our evidence. There was no supporting evidence, no corroborating evidence, except that there were denture marks on the left breast of the girl, of which the impressions could be easily taken out and where could be compared with the denture marks of the accused, so that the proximity of the accused could be established. But that evidence was not collected by the investigating officer, which he himself in the cross-examination had admitted was the substantial evidence. Now there was no corroborative evidence. So her evidence could never be accepted in these circumstances. Accordingly, I had to disbelieve her, taking into consideration all these aspects, and the accused was acquitted. Arguments were advanced that on behalf of the accused in the course of arguments, that this girl was wayward. She used to roam around in the village, and the medical report had said the body was subjected to medical evidence examination. It was found that she was habituated to sexual intercourse.
Okay.
And there were no marks, no indications of the forcible sexual activity on the said girl, which could be said that she was subjected to a rape. So all these things, all these lacunas in the evidence made me not to believe that woman, and the accused was acquitted. And as I said earlier, that objectively anybody could have jumped at the evidence of the woman, saying that she is the mother and she is wife of the accused and why she should depose. But when the duty is cast on the court to closely scrutinize the evidence, particularly the evidence of the relatives, near relatives, I think in that trial the duty was performed and her evidence was disbelieved and the accused was acquitted. So these are the finer things which are required to be gone into while scrutinizing the evidence and forming an opinion that the witness is deposing false. In judging the truth or the falsehood of the testimony of the witnesses, the courts have also to observe the factors like demeanor of the witness, their position, their characters, antecedents, their possible and probable motives for giving the evidence. The demeanor means the behavior of a witness in the witness box while giving the evidence. When the witness is deposing truth, one can easily see the confidence in that man while narrating the incident. Such a witness is never scared of speaking truth. But when the witness is not telling truth, his eyes, his body language, the manner in which he is giving evidence, if he is stammering or is incoherent or is hesitant in giving evidence, give out the signals that he is not telling the truth. The court has to be on guard while recording the demeanor of the witnesses. It has to closely scrutinize it. Even if the witness appears to be overconfident, it gives out a picture that either he is motivated to depose against the accused, or is tutored, or he has mucked up the evidence statement recorded by the police before he enters into the witness box. Many a times, the witness may have his own reasons to give evidence against the accused, or to say that the accused is booked by law and is sent to jail. Maybe he has a long-standing enmity against the accused. The demeanor of the witness under examination has to be minutely and skillfully observed by the court. This duty is cast on the sessions court or the magistrate or any court hearing the trial to record such remarks under section 280 of the CRPC. The remarks have to be respecting the demeanor of the witness in the course of examination as the court thinks material. There is a considerable significance attached to anything discovered in the demeanor of the witness. These observations go to a long way to help the court to find out as to how far the evidence of a witness inspires the confidence. The eyes of the witness, his tone, his voice, his body language, reflect the state of mind. And it gives a valuable clue to the court to come to the conclusion as to whether such a witness is the witness of truth or not. There may be a case of a witness who is an innocuous person, not recognized in the society, but all of a sudden he finds place in the courtroom. He is under the glory of attraction, he is the center of attraction. Then he tries to make all the most of the glory which he is receiving. So he goes on blabbering many things. In that process, he gives so many answers favorable to the accused. But that aspect also has to be checked. While totally disregarding his evidence, because he has given evidence in favor of the accused. But he is basking in the glory which he is receiving by being in the center of the stage and being in the witness box, which is a unique experience for him sometimes. Of course, there may be such witnesses also. So, the entire effort on the part of the accused is to discredit the witness by severely cross-examine the witness. At times, the character of witness is also sought to be assailed in order to show that such witness is not a trustworthy witness. Of course, the law puts certain limitations as to how far a cross-examiner can go while attacking the character of the witness. Sometimes the previous enmity of the accused and sometimes the previous enmity between the accused and the witnesses try to be brought on record. Many times there are contradictions between the previous statements made by the witness before the police and the statements made before the court. So these contradictions also go a long way to the affecting the credence of the witness. Here is a witness who is at one point of time says something, and at another point of time he says something and contradicts his own version. You just can't rely on such a person. Of course, these contradictions have to be material ones, not minuscule or insignificant contradictions. There are improvements also sometimes that they also go to the root of the credence of the witness. You just can't believe such a person who is stating one thing at one point of time and something. These are material things which go a long way to show the untrustworthiness of the witnesses. It must be remembered that the court has to believe in the words of the witness recorded by it in order to hold that the facts stated by such witness do really exist. The court has no other material to come to the conclusion that the facts are established, except on relying on the oral evidence of the witness in a criminal trial. So therefore, the aspect of appreciating the evidence of a witness in a criminal trial is of paramount importance. There may be cases where the witnesses are the relatives of the victim. You just simply can't brush away their evidence on the ground that they are the relatives of the victim. Like in the case which I had just narrated, the prime witness was the mother of the girl on which the rape was committed. Her evidence could not be disbelieved solely on that ground that she is interested in the victim. Here again, the strict scrutiny of the interested witness is required. I have tried to state some these few aspects which are required to be taken into consideration while appreciating the evidence laid by the prosecution. The evidence laid by the prosecution has to be such that it ought to inspire the confidence of the court that the alleged offence has taken place and no other person other than the accused has committed the offence. There are various aspects governing the process of appreciating the evidence, which in the limited time I may not be able to state them all. I expect that the people would take into consideration these aspects before they criticize any judgment. If it does not conform to their expectations, like I said, I hope that the young budding lawyers who want to make their mark in the profession would be benefited both while conducting the trials or assailing a judgment in an appeal court. I once again thank Advocate Rahul Naskar for giving me this opportunity to share with you all my thoughts. Thank you.
Sir, thank you very much, because it was like, a different way of looking at the case, or how evidence has to be appreciated, and at the same time actually we also understood how tricky position the honorable judges are there. Like, every time the grass on other side is not so green. It's something of that sort.
Correctly said.
So, sir, just a small token from Hamurami tablet to you, and thanks for your
Thank you very much.
contribution. Thank you, sir.
Thank you.
Thank you, sir.